Welcome back to Speak Van Holding 247 etc. And if you like, subscribe and share. Good morning to all my subscribers. Thank you for tuning in and thank you for staying subscribed. When I look at the previous judge conduct of sealing a court record as well as the probable cause affidavit at the request of the prosecutor, Nicholas McLeland, I must ask myself, and society must ask themselves, why would these two state actors, the prosecutor and the judge, why would these two state actors knowingly and intentionally go against the United States Constitution under the 14th Amendment, go against the Supreme Court case law dealing with that a defendant has, excuse me, that a defendant has a right to notice of the charges against him? Why would they go against Indiana Constitution? Why would they go against Indiana case law dealing with notice of the charges, as well as Indiana Code of Criminal Procedure, when this is clearly established law? In conjunction with that, the judge asserted that Richard Allen's life was in danger, as well as all the public officials that worked at the jail, and that he needed to be transferred to the state's custody in a prison. When I asked myself, why would they create these events? And one definitive answer came to my legal mind. They wanted to imply to everybody, the world, that Richard Allen is guilty. They wanted to taint the potential jury pool. They wanted to taint public opinion against Richard Allen prior to a fair trial on the merits. That is inimical to our nation's Constitution. It should be noted, I said it should be noted, that the very information, the probable cause affidavit that Benjamin Diener and Nicholas McLeland sought to conceal from the public, it should be noted that that very document, upon the hearing that Honorable Judge Friend conducted, Nicholas McLeland had already prepared a redacted version to give to the judge in any event that she felt it should be released. That, my friend, is a powerful demonstration that Nicholas McLeland knew the outcome of that hearing. It also is a powerful demonstration that Nicholas McLeland and the judge could have done that from the very beginning. So, as you can see, their conduct was clearly wrong. As you can see, they knew that their conduct had no law to stand on. I said this in a previous video, even before the ruling came down. If the judge made a ruling contrary to releasing that, she wouldn't be able to support it with case law or no law. So there was only one outcome to that. Now, that whole, how can I say it? Okay, that whole charade, like I said, was designed to achieve a particular outcome of a trial, which is a guilty verdict. And let me prove it to you. This is the icing on the cake. Here's another component to what they did with sealing the probable cause affidavit in the record, as well as claiming Richard Allen's life was in danger, as well as the state officials working in jail life was in danger. And here's another component to show you how they was orchestrating tainting the jury pool. Check this video out of Superintendent Doug Carter's statement, and you will see what I'm talking about.
Do you think Mr. Allen is the man on that bridge?
The judge signed a probable cause affidavit for the arrest of him. I can't wait to tell the story, but today's not the day.
When do you think you can tell that story?
We're gonna let the courts decide.
In other words, let them decide when they can release that PC.
Well, and then even then, remember, even then, when the PC is released, due process is still a piece of all this puzzle. And this isn't over until it's over. And that's where the conviction of him.
Did y'all catch what he said? The news reporter asked him, "Are you confident that was Richard Allen on the bridge?" He couldn't even say yes. He said the judge signed a probable cause affidavit. He goes on like a child. I can't wait to tell the story. Then he states, well, even when a probable cause affidavit come out, he's still entitled to due process. And that ends when he's convicted. What? So do you hear how he spoke with a double tongue? Let me put it another way. Do you see that he has already convicted Richard Allen? Why would Doug Carter, superintendent of the Indiana Police Department, after Richard Allen is arrested, state this to the media? Remember what I said, the whole secrecy of this thing was to achieve. You arrest Richard Allen, you seal the court record, you seal the probable cause affidavit, you claim his life is in danger, as well as the all public officials there. So he needs to be transferred to a state custody and put into prison to protect him. Why would you do all this here? And I stated the reason why. So Superintendent Doug Carter just proved my point. See, when I look at these press conferences that law enforcement gives, I look at it real close and analyze what they saying and how they saying it. So a lot of people didn't catch what I just explained here in this video. You have to have a serious type legal mind or some serious analytical skills to see what I have just showed you. Now, I will submit, I'm pretty sure Richard Allen's attorney, in their motion for a change of venue, didn't even argue what I just put before my viewers in this video, because their minds are not like mine when it comes to the law. My mind is a lot more superior. I will admit that. I can admit that. I just demonstrated that. Now, I will submit that I don't know all the evidence that they have, but I am going on the premise of what they have in a probable cause affidavit. So let me get to this bullet, this one particular bullet they got. It will boil down to the sufficiency of the evidence. And let me explain that. If a unbiased jury, once again, I'm not saying this is all the evidence they got. I'm speaking on the premise that this is all that they have, the hair fibers. If they don't have any hair fibers or any type of body fluids or hair to link Richard Allen then they are out of there. They should lose. But when you're dealing with a jury, it's tricky. But I will say the Supreme Court, as well as Indiana, they have the standard is sufficiency of the evidence. What that means and what it boils down to is this. Assuming that this is all the evidence they have in a probable cause affidavit and none of that, like the Herald, the fibers don't definitively link Richard Allen. One must look at that bullet alone, that one unspent shell, and say, can we say that this bullet places Richard Allen at the murder scene at the time that Libby and Abigail was murdered? Can we say that this bullet proves that he was there, he murdered or participated in the murder? A reasonable-minded jury would say no. That's what is called sufficiency of the evidence. Now, let me put it like this here. They seized clothes from Richard Allen's home that looked like the Bridge guy. I'm just going to say this here. Why would he keep clothes like that that's full of blood when it's easy to burn them or throw them in the trash? Why would he keep them? And see, that is a problem I believe that they understand they have with the case, because if they don't have something other than just this bullet, and I'm just going off this, I don't think they do. I don't think they do. Then they know, other legal minds know, that they will lose this case. But I'm going to tell you like this here, people. With jury trials, it's tricky, just like with Casey Anthony with her child. It can go either way, but one thing about it is, if they find Richard Allen guilty just based on this evidence that's in question, and nothing more than this bullet, they can challenge that on appeal for sufficiency of the evidence. And the court will look at that and say, how probative is it? What's the probative value in that? Meaning, what is the strength of this evidence in relation to this case? And they would lose. I mean, Richard Allen, in my opinion, would win on appeal, because that's really not enough, people, beyond a reasonable doubt. Because remember, the FBI was looking at Logan. Well, that's my take on it. Good morning to all my subscribers, and y'all have a nice day.